Okay, in the previous two sessions, we were talking, Robin talked in the first session about some kind of 10,000 or 40,000 foot issues. In the second session, we talked about really kind of one of the main planning issues of healthcare reform, which is player pay. And that's certainly more of a plan design and a structural issue that we think that people need to start thinking about, even though it's a little bit farther out in the future. But as you all know, healthcare reform has different waves of compliance issues that have come into effect each year. Some of those compliance requirements have already come into effect, and but we have more compliance requirements that are coming into effect every year. And so what we want to talk about in this session are the things that are the compliance issues that you currently need to address right away, need to devote resources to, and make sure that you're on the ball on getting those done. So in this session, we have two speakers. We have Brandon Long and Allison Patel. And Brandon's going to talk about medical loss ratios and rebates and the summary of benefits and coverage. And Allison is going to talk about the W-2 reporting requirements and flexible spending accounts. So we'll start with Brandon.
Good morning. Allison and I were in a meeting a few days ago where we were divvying up who gets to talk about what. And, of course, the boss, they sit around and they talk about all the really interesting, exciting stuff. Believe it or not, there are, to us nerds, player pay is kind of where the action is. But Allison and I end up with 5 or 6 good topics, practical topics that literally, like medical loss ratio, rebates, we've been fielding calls on literally last week. So some of the issues we're going to talk about here may be a little more practical. We are a little more in the weeds. Forgive us for some of the boring material. But, and by the way, on that note, and I will get to my stuff, but in Robin's presentation, I was in the back, and she said, boy, I'm glad I don't have to talk about summary benefits and coverage. Well, guess who gets to talk about that? So, okay. Starting January 1, 2011, insurance companies have certain medical loss ratio standards that they have to worry about. And we're not going to spend a lot of time on this slide, but generally the idea is that insurance companies, they've got to pay out a certain amount of money that they're bringing in. So for large employer groups, and generally that's folks with over 100, it's like 101 on average employees or more, they have to spend 85% roughly of the premiums that they bring in on claims and quality improvement. And it's a lower number for those in the small group market. If they fail to meet those standards, which again, the calculation of that is really not something that most of you are probably interested in. But what does happen is, and this was for 2011, people now, by August 1, the insurance companies were required to rebate you a check. And this only applies to those of you that have fully insured medical plans. So I get a call from a good client that says, hey, we've got a check for $10,000. What is it? And what do I do with it? Well, the issue is, and by the way, I'm kind of talking two groups. First, we're going to talk about most of you that have ERISA-covered plans. Those of you that I would put into the non-ERISA category, governmental employers, tribal employers, we'll talk about, this applies to you as well, but we'll talk about that in a second. So for those of you that have an ERISA-covered plan, the issue is that this money is potentially ERISA plan assets. And the ERISA fiduciary duties that are associated with ERISA plan assets are very high. Duties of prudence, duties to use money solely in the interest of plan participants and beneficiaries, the duty to protect assets, a lot of times duty to hold money in trust. And so all of those ERISA fiduciary duties can be associated with these rebate checks depending on if the rebate is an ERISA plan asset. To determine if the rebate, the checks that you get, to determine if that is an ERISA plan asset, you have to look at, it's a facts and circumstances kind of deal, and this is the easiest way to think about it. If you're an employer and you pay 100% of your employees the premiums for the coverage, probably very few of you do that, but if you paid 100%, then you could take this check and do whatever you like with it. Not going to be an ERISA plan asset. But for most of you that have, let's say you pay 60% of the premium for your employees and they pay 40%. It's really that simple. 60% of the rebate is going to be your money that you can do with whatever you like, and the 40% you need to worry about it being an ERISA plan asset. You got to figure out what you are going to do with the money. You have several options. You can either refund the money to the participants. It's administratively, I think, difficult. Who do you give it to? Do you give it to folks that are currently employed? What about the people that were employed last year but are no longer employed? What about tax issues? So the money, most of the folks that are paying their portion of the premium are paying them pre-tax to your cafeteria plan. They get a refund check. That's going to be taxable income. How do you do withhold? All sorts of weird tax issues, which you would need help on. Probably the more likely scenario for most of the folks that we've been helping is that they give people a premium holiday, so you can do that. And the good news is the Department of Labor's guidance, the technical guidance, gives you some flexibility. If you're allocating the premium to your participant population, you don't necessarily have to worry about those. If you're giving a premium holiday, you don't necessarily have to worry about those that no longer work for you. So that's good. Non-ERISA plans, it's the same kind of stuff. Now, it's some of the slides that we talk about and some of the things that we talk about, like employer shared responsibility, what they talked about in session 2, and the PCORI payments, which I get the pleasure of talking about here in just a few minutes. There's no clear carve-out for what I would call non-federal governmental entities. And this is another example of something in healthcare reform that applies to you that may seem strange, but even if ERISA does not apply, you have duties under the guidance to, and if your employees are paying a portion of the premium, you have duties and guidance that you have to follow also. And it's basically the same thing what I just said. It's a little different, and if you fall into that category, I can certainly help you with that, or we can help you with that, or your consultant can. But it's basically the same thing. You've got to determine who pays the premium. If your employees are paying the premium, you can use it to give them a refund, or you can use it to offset costs. Okay, here we go, folks. This is one of those things, if I'm in your spot, and I've been sitting in the back cramming, reading this stuff for the 1000th time so I can get up and speak in front of all of you nice people. But if someone called and asked me a question, honestly, about any of this stuff, and the same is true for these other smart folks that I work with, they're going to pull out the guidance and look it back up because it's very, very complicated. And you're really, I'm going to talk about summary of benefits and coverage. What is it? What is the deadline to provide it? Who provides it? Who gets it? What's got to be in it? But really, this is not something that you should be dotting your I's and having to go through and make sure that everything that's in the summary benefits and coverage is in it. Your consultant should be handling that for you. And this ties back into kind of the overall theme of today, if you haven't figured out, is you really need great people on your team because this kind of stuff is very detailed, very easy to mess up. What I'd like to do is kind of start at the end. If you look under I think it's tab 4 in your book, behind that worksheet that they just went through, because it helps me to kind of tangibly see what we're talking about. This is the format of a summary, an example summary and benefits and coverage. Healthcare reform requires that a summary of benefits and coverage be provided to applicants and enrollees before enrollment or re-enrollment. It's got to accurately describe the benefits and coverage, and the idea here is we want people to, and employers too, because insurance companies issuing policies to plan sponsors have a duty to provide this as well. We want people to be able to understand what their benefits are. We want them to be able to compare. This is one of those requirements that applies to everyone, regardless of whether you're grandfathered or non-grandfathered. It applies with respect to open enrollment periods beginning on or after a month from now. It applies to open enrollment periods beginning on or after a month from now, September 23rd, 2012. So for those of you, for example, Bill's Bait and Tackle Shop. Big Bill's always talking, we always pick on Bill, but he's always talking about opening up a bait and tackle shop down at the river and retiring. He opens up a bait and tackle shop. It's a calendar year. He provides a calendar year benefit to his employees. But his open enrollment period starts October 1. This is going to apply to the open enrollment period and will have to be provided to those going through open enrollment starting October 1. So, and then for new hires, for everybody falling outside of that. So, for example, you have a calendar year plan, starts January 1 of 2013. You get a new employee. This is going to apply to those folks starting January 1, 2013. Which plans, self-insured medical, fully insured medical, certainly you're going to have to comply. It really applies on a, quote, benefits package basis, which is something I'm not going to bore you or myself with getting into, but it's really, it can be kind of complicated because that's not really defined in healthcare reform. But what it does not apply to, clearly, are accepted benefits. So, for example, standalone dental, standalone vision. If your FSA account, for a lot of you, including like McAfee and Taft, where the FSA benefit that's provided is only for employee money, it will not apply to that. HSA, if you have an HSA and a high deductible health plan, it's going to apply to the high deductible health plan, but not the HSA. And on the HRA, this is another one of those complicated areas that you're going to need some help. If you provide an HRA and it's an accepted benefit, it's not going to apply, but you need to go through that analysis to determine if it is accepted or not. If you're self-funded, the obligation to provide the summary lies with you, the plan administrator. If it's fully insured, it's a dual obligation of both the plan administrator and the insurance company. Who gets it? Generally, applicants, those that are applying for the first time for coverage, those enrolling, and policyholders. And again, another example of a policyholder would be the employer buying an insurance product. It's distributed during open enrollment, initial enrollment when someone's first hired. It's special enrollment for those weird situations where people are eligible mid-year. You have to provide it at that time. And upon request. If someone requests a copy of the summary of benefits and coverage, then you have to provide it as soon as possible, but generally within 7 business days. Now, keep in mind that this requirement is one of a gazillion other requirements that we're always worried about, like, for example, the summary plan description that we all have to provide if we have an ERISA-covered plan. This is separate from that, in addition to that. Manner of delivery. You can either mail it to folks, you can hand it to them. You can also provide it electronically for those people that have access to a computer as part of their job. I bet you a lot of folks in here have thought about electronic delivery of benefit documents in the last 5 years, because we get a lot of calls, and we have a really great worksheet, by the way, that we can provide you if you're interested. But you know, there's kind of an analysis you go through. Does the person use a computer as part of their job? If not, then you got to get their consent, and you got to meet certain requirements. Well, all those rules apply here. And then they've also provided an additional safe harbor for those enrolling electronically. If someone's enrolling or re-enrolling electronically, you can provide the summary of benefits and coverage electronically in connection with that process. The appearance, this is the part where that document behind, the sample behind tab 4 will be helpful. It's got to be a uniform format. You've got to actually use this format, and it's on the website. You can find it on the web. We can direct you to that website if you're interested. You've got to follow their format. It's got specific instructions. It's got this template instructions. It's got an explanation of how you make calculations, how you fill in the boxes, and you've got to follow all of those very detailed. Cannot exceed 4 double-spaced pages. I was looking at the instructions again to cram for this, and they say things like this row has to be on this page. And again, most of you folks wear a lot of different hats. This is not something your advisors, your consultants should be helping you with this. It cannot include print smaller than 12 font, and it's got to be presented in a culturally and linguistic format. So, and on this latter point, the rules dealing with the claims and review process apply. So if you're sending a summary of benefits and coverage to a county in which 10% of the folks in that county speak a non-English language, then you have to include a sentence about providing it in an alternative manner. Uniform definitions, description of the coverage, exceptions, reductions, and limitation on coverage, renewability and continuation of coverage provisions. I think it's one of the pages you'll see some language about Cobra in your example. And again, the instructions are so specific that they say you literally have to use this language. Coverage examples. In the current available template, there are two coverage examples provided, one for pregnancy and one for, I think it's type 2 diabetes. And you can see how the coverage examples are supposed to work. And again, the idea is to give people kind of a real life, here's what the claim is, here's how the payments would work. After January 1 of 2014, you have to include additional information. For example, it's going to have to say whether the plan provides minimum essential coverage, which ties back into what we've been talking about earlier. Okay. And you guys, I'm not going to read all of these little details, but you can see like the internet address. If you provide a network of providers, I believe it's on page 1, maybe one of the last boxes, you'll see a space to put in an internet address. But that format there will cover all of these. So if you don't provide it, you can be assessed a penalty up to $1,000 per failure. So this is a big deal. Just, again, add this to one of the many other things you have to worry about. Okay, Allison's turn.
Okay. Was everyone still with us? Summary of benefits and coverage has really been getting beat up on today, but I think I'm probably the one person that really appreciates it because it's going to make everything that I'm going to talk about seem like a walk in the park. So it's made my job a lot easier to follow that up. Good planning by me, I think, to follow that. But the next topic we're going to talk about is the flexible spending arrangements, and more specifically, the new $2,500 limit that's been imposed on salary reduction contributions going into a health FSA. Basically, what this is that healthcare reform amended Section 125 of the code to provide that you can't, for a taxable year, you can't allow an employee to defer more than $2,500 into the health FSA. This is, as Robin mentioned in session 1, this is one of those revenue-producing aspects of healthcare reform. So that's really the entire reason behind it. It seems pretty straightforward. You know, you've got a $2,500 limit. Doesn't seem like there'd be much more to it than that. There are, however, some nuances to it when you get into the practical aspects of applying this to your plan. And thankfully, the IRS has come out with some guidance in the form of Notice 2012-40 for how this applies. One of the biggest uncertainties for a lot of employers was for the employers that have non-calendar year cafeteria plans. And what does that definition, taxable year, really mean? So the IRS has come out and clarified and said the taxable year, really we're talking about a plan year. So for cafeteria plan years that are starting after 2012, you have to comply with this new limit. So that's given everybody a little bit of relief. Unfortunately, that notice didn't come out until May of this year. And so some employers already went ahead for fear that they wouldn't be compliant, that had non-calendar year plans, and reduced that limit already. To the extent that you've done that, there's really no going back now. If your plan year is started, you can't now go back and change what that limit is. So you're pretty much stuck. Another little wrinkle to this is that it's based off of a cafeteria plan year. Is there anybody that has a cafeteria plan that has a plan year that's different than the plan year for the health FSA? Oh, well, I'm glad at least one person is listening to me. That makes me feel better. In that case, it becomes a little bit questionable because since it's based off the cafeteria plan year, the conservative approach a lot of people are believing is that you would need to start your health FSA the year that prior to the cafeteria plan year that's beginning in 2012 for fear that that limit would be broken to the extent that your health FSA plan year overlaps into 2013. So there is that additional wrinkle. Other clarifications provided by the notice is that this only applies to salary reduction contributions. So employer contributions don't count. Now, I will say that to the extent you're doing flex credits to your FSA and the employee can elect to use those flex credits for cash or other taxable benefits, that's still considered a salary reduction contribution. So that would go towards your limit. But standard flex credits that can only be used for qualified benefits, not counted. Also, in keeping with that, this wouldn't apply to dependent care. It wouldn't apply to premium payment plans. It wouldn't apply to your HSA or HRA. So it's somewhat limited in that respect. There was also some confusion regarding what happens with your grace period in your FSA. So if people are rolling amounts over to a subsequent plan year for use during the grace period, does that amount that's being rolled over count against the limit for that next plan year? And they've come out and said the answer to that is no. So the $2,500 limit, can that be modified depending on how many dependents you have covered, if you have a spouse, children covered? No. For every employee, it's the same limit regardless of number of people covered under that employee. You can, however, if for spouses, if you're both enrolled in your employer's health FSA, you both get your separate $2,500 limit. The controlled group rules do apply to the FSA limit. So if you have a related group of employers and you have any employees who are working for both or more than one employer in that related group, and all of those employers or some of those employers have health FSAs, that employee still is subject to just the $2,500 limit across all of those health FSAs. Now, if you have an employee that's working for an unrelated employer, you do not need to be concerned about whether or not they're deferring into that employer's health FSA. The limit can apply to the two separate. The big issues of not wanting to exceed this limit is just basically that the penalty is pretty severe, and that's that you lose your tax qualified status for the health FSA benefit that you're providing, which is obviously something that you wouldn't want to have occur. I don't want to confuse you with the documentation requirement. The operational requirement goes into effect for cafeteria plan years beginning after 2012. So that's firm. But as far as amending your plan document, you have until December 31st of 2014. So you have a while to get your plan document amended for this. But operationally, again, end of this year. There's also going to be an opportunity for self-correction of the excess contributions to the extent that it's a mistake. It has to be a reasonable mistake that you're fixing. It can't be a willful neglect of this rule. But if there's a reasonable mistake, and if you've been applying the limit across all participants uniformly, then to the extent that you include the excess amounts in an employee's income once you find the error, that would be considered a correction. Now, this wouldn't be available to you if the IRS already has you under examination. And that can include just a written notification from the IRS that there's been an error. So you want to have self-audit and payroll checks in place so that you know quickly if there's been someone who's exceeded the limit so that you can correct it yourself. So what do you need to be doing now? Well, even though the plan document requirement's not in effect until 2014, you are going to have to get out communication materials and election forms to your employees. And as Robin mentioned, this is going to be somewhat of a communication issue for employers because it's probably not, this that I'm talking about is probably something that you know much more about than some of the other topics. For those of you sitting in this room, it is going to come as a surprise, I'm sure, to plenty of your employees that this amount is being reduced. So it could become a communication problem, so you want to make sure that all your materials are very consistent as far as the way that you're going to approach this. You might also consider how you want to approach it. If you want to leave it firm at the $2,500 limit, if you want to have an auto increase for any time there's an inflation adjustment, there's advantages to both. With the base limit, you could revisit it in later years, and that way you don't have these incremental adjustments that are not necessarily the easiest for employees to understand. So consider things like that. Go ahead and get started on thinking about how you want to revise your plan and getting that process started to make sure you meet that deadline, and also make adjustments in your payroll systems to make sure that you're catching that limit and that it's been modified. I will say that some employers have considered and talked about changing their plan year so that they can delay this requirement. I would say to you that you can only do that if there's a reasonable business purpose for doing that. So the IRS has kind of tried to avoid allowing employers to get cute on this. And so unless there's some other valid business purpose for moving your plan year, you're really locked into whenever your plan year is starting after this year. Well, this one's probably going to be a little bit more painful, I have to admit, on the front end. W-2 reporting is never exactly the most popular discussion, but basically what's happened with healthcare reform is that employers are now required to report the aggregate cost of applicable employer-sponsored coverage on an employee's Form W-2. And that requirement starts for the 2012 Form W-2. So the W-2s that you'll be issuing to your employees in 2013 for the 2012 year have to be compliant. So there are, I will say, a lot of exceptions to this rule provided through transitional relief, but to the extent you're one of the employers that's not eligible for any of those relief provisions, you should definitely already be in the process of figuring out how you're tracking these costs for the 2012 year, since we're already into it, for the W-2 that's going to be issued in 2013. It's also important to note that this is not going to change the taxability of the coverage that you're reporting. This isn't, the fact that it's being reported on the W-2 does not make it taxable to the extent that it's not already. And it's really for informational purposes. That was the goal behind it, at least, is that employees would be able to look at their W-2, look at box 12, see what code DD says as far as an amount, and understand what the cost of their coverage is. So it's truly intended at this point for informational purposes, so you don't need to worry about that. Also, if you have employees, or I shouldn't say employees, if you have individuals who you're not already W-2ing for some other reason, you do not have to W-2 them solely for purposes of this provision. So if they're not receiving it otherwise, you don't have to provide them one. Let's get right to, what everybody cares about mostly, I think, which is what's really the penalty if I don't do this? Well, it's somewhat unclear at this point still, but basically what everybody is assuming from the guidance is that it will be the same penalty that you would have for any other failure to file a correct W-2 for an employee. And I've got a typo in there, so it's not a failure to fail, which would actually be a success, I guess. It's a failure to file the W-2. I got a little bit overeager, I think, with everybody potentially failing. So and for those of you who have never had an issue with your W-2s, those penalties can actually be somewhat severe because they go on a per employee basis. There are maximums that are applied to it, but they're pretty steep. And so if on a wide basis you've not complied with this with your employees, then it could be fairly expensive, especially if it was an intentional disregard, because then there is no maximum limit to those penalties for W-2 failure. So this is definitely an important one. The good news, though, back to this, is that there is relief available for probably a lot of you that are in here. And I'll get into that later in the slides, but there is some relief available through guidance that was issued by the IRS in 2012. First, we have to start with who it applies to generally to figure out who we can pull out of it. So generally speaking, it almost applies to everybody. It's really an employer who has applicable employer-sponsored coverage, which it covers mostly everybody. It covers private sector employers. It covers government employers. There is a limited exception if you're mostly employing military personnel, and the covered people are mostly military personnel and their family. And then it also covers churches and other religious organizations. So, and it also applies whether or not you're subject to Cobra. So this really, it's a broad sweep before you get to the exceptions. So now to what you all are hoping or is going to apply to you, which is who's not subject to the reporting requirement. Federally recognized Indian tribal governments are not subject to the reporting requirements. There's also transitional relief for tribally chartered corporations that are wholly owned by a federally recognized Indian tribal government. So it's clear on the first one. The next one is the transitional relief that's being provided right now through this guidance. Also through the transitional relief, employers who for the preceding year filed fewer than 250 Form W-2s. So if in 2011 you had fewer than 250 Form W-2s, you're not subject to this. I see some people doing a happy dance. And this is early for me, I think, to give this away because now I've lost most of the room, I think. But I'm saying this only because this is transitional guidance. This is temporary. So when the IRS publishes new guidance, if it's not the same, you may still be subject to these requirements. So please continue to listen, if not for my benefit, then for your own. Another good thing about the $250 limit is the control group rules don't apply either. So you have an even better chance of meeting this exception because you're not required to include the W-2s that a related employer would have also issued. So that's a big exception for now. And also for employers that are contributing to a multi-employer plan, no reporting requirements for those employers at this time. For the transitional guidance, I just want to remind you, it's temporary, but it's guaranteed for the 2012 year. So it's not as though they're going to come in December and say, nope, we've changed our mind. Here's this new guidance. You need to abide by it. But once it's issued, to the extent it's a year starting later than 6 months after the guidance is issued, it will go into effect probably around that time. So just keep your eye out for any transitional guidance or final guidance that's given on this topic. What is it? Applicable employer-sponsored coverage? It's basically any type of group health plan that's excludable from your employee's income. But there are types of coverage that are not subject to this. And there's really a great chart in the IRS, on the IRS website that to the extent this does apply to you this year, I would recommend that you go there. They have a fantastic chart that goes through different types of benefit coverage and tells you whether or not you have to report or you can optionally report. So I'll just breeze through these quickly though. Long-term care, not required to report. Standalone dental and vision or dental and vision to the extent that you have to elect and then pay a premium to be in those plans are not subject to reporting. HIPAA accepted benefits like AD&D, disability income, liability, whether it's auto or general, workers' comp, auto medical payments, credit-only insurance. Those are all accepted too, as well as any other similar benefit where the medical benefit is really a secondary benefit to the insurance. To the extent an employee is paying for it on an after-tax basis, any independent or non-coordinated specified disease policy or hospital indemnity or other fixed indemnity insurance are not covered. HSAs, Archer MSAs, HRAs, salary reduction only, health FSAs, all not covered. Employee assistance programs, wellness programs, on-site medical clinics for employers to the extent a premium is not charged are not covered. So those are plans and types of coverage that you don't need to worry about including in your aggregate cost. Now, how do we figure out what's the cost of those plans we do have to worry about? First of all, both employer-paid and employee-paid portions of the cost are counted. And for the employees, it's whether it's after tax or pre-tax. So you have to include it all. It includes any cost of coverage for the employee and any person that's covered underneath that employee. So their spouse, their children, their dependents. You have to include the cost for all of that. It's not going to be reduced by any imputed income. So for those that provide domestic partner options or the availability for coverage for children over the age 27, that it's included in your income, that doesn't mean that it's not being reported as part of the cost of coverage. You don't have to include, though, any amounts that were included as excess reimbursements of highly compensated individuals in their gross income. There's also special rules that apply to health FSAs when there's employer flex credits, and depending on what coverage is more or less. I won't get into that just because it may not affect many of you. Calculating the cost of coverage. You can use any of these three methods to calculate the cost of coverage. And if you have multiple health plans, you can use different methods for different plans. But once you've decided on a method for a particular plan, you have to stick with it for all the employees. Cobra applicable premium method. You're basically using this. To use this, you basically have to comply with the requirements in 4980B of the Internal Revenue Code, which is the Cobra stuff that you're probably already dealing with. And it basically just means that your premium rate has to be something that's a reasonable interpretation of the statutory requirements for Cobra. So a lot of you probably already have established these Cobra applicable premium rates. And so to the extent you have, a likely a lot of you will be using these as your cost of coverage. The premium charge method is only available for insured plans. And to the extent that you have an insured plan and you use it, you have to use the premium that's actually charged by the insurer. The modified Cobra premium method, for those of you who don't have a Cobra applicable premium already and are just using an estimate, and if you subsidize your Cobra cost, or if you're using a prior year coverage method or prior year cost method, you might be using this. It's a little bit more involved as to what you use, but the generality of it is that if you're subsidizing, it's the premium without the subsidizing. And for the prior year, to the extent it's not going to be any less or more, then you can use the same premium. It's worth pointing out that you may have employees that are having status changes, or your insurance provider may change the premium amounts mid-year on you. In those situations, you do have to actually account for the increase or decrease that happens mid-year. So if someone has a status change in the third month, you're going to have 3 months at one rate and 9 months at another rate. And you've got to combine those for purposes of getting your aggregate cost. So you have to track the coverage that's being utilized by your employees. So that's a difficult aspect of tracking the W-2s. So that being said, though, that's the end of that.
This is real quick. Last topic. So the Patient-Centered Outcomes Research Institute, the new nonprofit that healthcare reform created, is to be funded in part by fees paid by plans and insurance companies. The fees are payable for policy and plan years that end after September 30th of 2012, and the fees stop applying for policy or plan years that end after September of 2019. What this means is for calendar year plans, there's going to be fees from 2012 to 2018. So, for example, if you have a calendar year plan for 2012, you're going to have a fee calculation and a payment due in July of next summer. It's payable by insurers and sponsors of self-funded plans. This also is one of those weird things for those of you that are governmental entities. I was even just looking last night because it seems wrong to me that governmental entities of any kind would be subject to this, but I don't really see a lot of good exceptions. There are some exceptions, but I don't see any. So again, for those of you that are governmental or tribal governmental employers, this is a fee that we need to be thinking about, which is also kind of weird because it's paid on a quarterly excise tax return, which many of you may not even have to mess with, usually. Doesn't apply to accepted benefits. Again, example of that would be standalone dental, standalone vision. But major medical, for example, fully insured medical, self-funded medical, those plans are subject to it. The fee is $1 times the average number of covered lives, at least for now. The fee goes up to $2 next year, basically, and then it goes up even more for years after that, and it's adjusted based on some weird actuarial calculation. The question is how you determine the average number of lives that the multiplier is based on. And you have three methods. You have an average method where you can basically count the number of employees every day of your year, divide it by 365, multiply that times $1, that gives you your fee. There are a couple other methods, one based on the number of folks you report on your 5500s, if you file 5500s, and another based on a kind of a snapshot method. The fees are reported and paid once a year. As I mentioned, they're paid on a quarterly, it's once a year, but you use a quarterly excise tax return. And for payments for policy and plan years that end in a calendar year, the payment is due the following July. So again, for policy and plan years that end in 2012, you're going to be having to pay this fee in the summer of next year. And again, this is one of those deals that somebody needs to be helping you calculate and this should not be something you have to worry about. If you have questions, we'd be happy to take them afterwards. Thank you. Johnny?
Well, as you can see, healthcare reform is continuing to generate new compliance requirements and will continue to do so for the next few years. I think every speaker has made this point that we all think that it's really important to be proactive on this and to devote the necessary time and resources of your department. Unfortunately, it's an extra burden. But we've tried, in these presentations, we've tried to point out, as you're going through this, we hope you keep in mind some of the traps and the tips that we've brought up in our presentations. And, of course, if you need any assistance, please let us know. Thank you for joining us today. We have a few extra booklets, program booklets, still available. So if you want to take an extra home or back to the office for someone else that couldn't be here today, please do so. And we appreciate your coming here today. Thank you.